The Indian Federation of Women Lawyers Karnataka had organized a lecture program at the Magistrate Court Unit Ladies Room on November 17, 2023. The subject discussed was Domestic Violence Act New Challenges. The guest speaker was Srimati Jaina Kothari, designated Senior Counsel of High Court of Karnataka. Number of women lawyers practicing mainly in the magistrate court participated in the program that day and actively discussed about the problems and the ways and means of getting reliefs for the women victims of domestic violence. Here are a few pictures and clippings of the said program.
Indra Sharma versus VKV Sharma, and the court actually, it's a really interesting judgment if you all have a chance to read it, because the court looked at living relationships and criteria of living relationships for many other laws in different jurisdictions. Looked at Australia, it looked at the UK, Canada, where live-in or civil partnerships, they have another provision. If you don't want to get married, you can have a civil partnership. So how do they look at living relationships? And then the court culled out some guidelines that relationships in the nature of marriage in the DV Act or living relationships, what should be the criteria? How do you decide, yes, we were in a relationship in the nature of marriage? And some of the criteria is the duration. Was it a substantively longish relationship? Did they live together in a shared household? Were they pooling the resources in some way? Did they have any other domestic arrangements? They were living together, things like that. Did they have a sexual relationship, existence of a sexual relationship? Whether they were socializing in public together as a couple, and what was the intention and conduct of the parties? What was their conduct generally? And so all those should be the criteria. In her name, the house is in some other family member's name, or it is a rented house. That is the easiest way to throw her out. Or even if she's not thrown out, the husband will leave the house and will stop paying the rent, and then will collude with the landlord to give her a notice to evict. So she can't pay the rent, and she's thrown out. Then you have to go to court and say direct to pay in order to pay the rent. But we've had all of you are doing so many. We are all doing all these matters. We file that landlord will file eviction suit. All kinds of things will go on to ensure that she's thrown out of the house. So initially there was one judgment which was in fact quite a negative judgment, Batra versus Batra, which was in 2007. It was quite a negative judgment, and it was a Supreme Court judgment. And in that, the house was owned by the mother-in-law. Who is the presiding officer in that judgment? Negative judgment. Just see who was the judge in Batra versus Batra. So in Batra versus Batra, the house where the woman was thrown out of and she wanted the right to reside in the house was owned by the mother-in-law. The husband threw his hand up, this is not even my house, this is not my home, it is the mother's house. And the court said that shared household will not, I can either be the husband or otherwise it cannot be the mother-in-law's house, and in fact gave a judgment where she does not have a right. And for a long time that Batra versus Batra judgment was holding the field.
Yeah.
Recently now, there is a new decision of 2020, Satish Chandra Ahuja versus Sneha Ahuja. Here the Supreme Court has ruled Batra versus Batra and has now held that shared household, there will be certain criteria. And those criteria are very important. They said that to decide whether the house where you are living, to which you want some right to reside, is a shared household or not, there are certain criteria. You have to look at the nature of living, how they were living there. They were living there together as a family, as a domestic unit, intention of the parties, nature of the household, how they were using it. It is not required that either the aggrieved person should own the premises or should have it in her name, even jointly or singly. Household can be owned by the joint family member, even if it is not the husband or wife, and not even the respondent. It can be owned by anybody else also. That's also not a problem. And the shared household can be either owned or rented by the respondent, single, joint, anything. But you have to determine the nature of the living. Were they living there as a shared unit, whether as a family or a couple, etc. So, in this way, it effectively overturned Batra versus Batra. So, again, we have the protection of this. Then another issue on which we've had a recent judgment is in live-in relationships. And live-in relationships again are quite complicated. We've had cases where it's very difficult to prove that they were in a live-in relationship, because if there is no marriage or no documentation, the first thing the issue came on limitation. Now limitation often comes. See, I mean, all these issues come up because the minute a DV complaint is filed, either an application is filed in the same court to try to dismiss it, there's no jurisdiction, it's beyond barred by limitation, etc., or a 482 petition is filed in the High Court to quash it or to stay it and ultimately quash it. So all these grounds are taken even at the 482 petition stage. There's no limit, it's beyond limitation, it could never have been entertained, it's no jurisdiction, it could never have been entertained, all these issues. So in one case, it was a 2020 Supreme Court decision in Kamachi versus Lakshmi Narayan. Here, an allegation was made, the government taken by the respondent was this is barred by limitation because the domestic violence alleged had taken place many years ago. And under 468 of the CRPC, which has the limitation given for each offence, depending on the punishment, it's 1 year, limitation is 1 year, or if it is beyond 3 years punishment, then the limitation is beyond that. So the argument was made that this is beyond limitation, it's barred by limitation as per section 468 of the CRPC. When the matter went up to the Supreme Court, the court said that this is not a criminal law, it's a civil law. And these domestic violence, even if a finding is given, it is not a criminal offence under the PV Act. It becomes a criminal offence only under section 31. That is, if there is a breach of an order. If there is a breach of a protection order given by the court, then under section 31, that breach becomes an offence. But all other averments or allegations of domestic violence, which can lead the court to give some remedy, these are not criminal offences. It's a civil law which provides civil remedies. So 468 limitation will not apply at all. 468 limitation will apply only in the case of section 31, which is about the breach of an order. Only to that extent. And therefore the court said that the limitation will not apply, and government was made that the allegation was that the domestic violence happened 10 years ago. So the court said it's up to the magistrate. Looking at the facts of the case, up to the magistrate to decide. But there is no bar on the limitation as per the CRPC. So this also can be used quite positively.
Offensive.
Now there have been quite a few decisions on the shared house. Because one of the big issues or the big areas is the woman is thrown out. Orissa High Court. There was a complaint where there was a live-in relationship between a woman and a trans man. And here the court held the aggrieved person is a woman, but her partner was a trans man, and the court said that she would be entitled to relief under the DV Act, even if the court said that that person was of the same gender. But the woman she was in a relationship with a trans person, would be entitled to relief. The question is normally the other way, where a trans person is getting harassed or getting abused. Then would they have the right to approach under the DB Act? Then I move on to jurisdiction. I'm just picking out some new judgments, just so that you have an idea. Jurisdiction has often been raised, where to file it. Of course, the Act gives a variety of places. It can be filed where the cause of action of the domestic violence took place. It can be filed where the petitioner is residing. And it can also be filed where the respondents are residing. So this was a case which went to the Supreme Court, Shyamlal Davda versus Parimala from the Karnataka High Court. And here the woman had filed the complaint where she was residing, but the marriage was elsewhere. They were married elsewhere against her husband and in-laws and many other family members. Marriage was elsewhere and they were all residing elsewhere, and she also used to live elsewhere when she was married. Now she has come to her parents' place and she had filed it. And they had, the respondents or the accused had all challenged it, saying the court has no jurisdiction because none of the acts took place there. All people are in different states, and the allegation was made that she's trying to harass everybody. The Supreme Court ultimately said that no, there is a provision that can be filed where the lady is residing, and often she comes back to her parental home when there is a lot of violence, and therefore we can have jurisdiction there.
It's the Supreme Court.
The court said that Section 2A, which has the word woman, that is the aggrieved person, is no more limited to the binary of women and men and includes a transgender person who has undergone sex reassignment surgery. Against this judgment, there is an appeal that has been filed. So this matter is now before the Supreme Court. So we will have to see how the Supreme Court interprets it, whether they uphold it or they don't. If they do uphold it, it will be a really quite a broad coverage. In fact, there are many laws like the Sexual Harassment and the Workplace Prevention, the POSH Act, right? When we are wanting trans persons to be at work, they face harassment. Again, that is only for women. And there is a need, there is a demand from the community that woman also should be broadly defined. At least it should include trans women. You know, so that hasn't happened yet. But the DV Act, Bombay High Court has held, and now it is pending before the Supreme Court. There was another interesting case. There was another interesting 2022 Hafsora versus Hafsora.
ಯಾರಿಗೆ ಮಧ್ಯೆ ಕುಡಿತ one cup will have cup.
No, issues. So Justice Nariman, in fact, gave a decision which in some ways is a regressive decision, where he said that if the idea is to protect violence, women from violence, the violence can come from anybody. Why should it why should the section say, definition say respondent in some incidents only mean adult male? It can happen from anybody. And if the idea of the object of the law is to protect violence, then the violence should be protected from everybody. So he gave a judgment which said that that section would be read as adult male having been deleted.
Oh.
So then, of course, this judgment, I'm not really aware whether it is being implemented wherein the application of DB Act are in fact filed against persons and seeking reliefs also who are female. The question comes, if you remove adult male, can it be implied that it can be applicable even against a minor? Because even the word adult is removed. So this judgment has some far-reaching, can have a far-reaching impact. But I don't think it is being used to such a large extent, at least at the moment. It's just a 2018 judgment. Yes. Then there was one Bombay High Court judgment, again on the issue of who can be either an aggrieved party or a respondent. think these are issues which are of relevance. This was a case where an aggrieved person was a trans woman, was a transgender person. Now the act is very clear that it is only aggrieved person can only be a woman. And this is a real serious issue where trans persons, trans women are facing a lot of harassment from their family members. So what happens, what relief or what recourse do they have? And so in the act. And also we had cruelty under the both matrimonial laws and the criminal laws. The cruelty was not defined. It was just mental physical cruelty. We had to rely on court decisions for an elaborate understanding of cruelty. And women faced cruelty or domestic violence in a variety of ways. Mental abuse, physical abuse, verbal abuse, but there was also sexual abuse, which was never there, never explicitly mentioned as a form of domestic violence. And there was financial abuse, where her earnings were taken away, all her properties were taken away. She was not given control of her earnings. All of this was financial abuse. That was nowhere there. So the law was also made to put and define domestic violence from a woman's perspective. What is violence and how she experiences it. So all these were the key features of the DV Act. And for that purpose, the DV Act was enacted. One of the other things was that it was not just marriage. Hindu Marriage Act, matrimonial laws, 498 only addressed cruelty within marriage. What happens to women who were not married? So women living in live-in relationships, living in all the nature of marriage. They had no recourse. Secondly, what of domestic violence which happened outside of marriage, by native family, right? By other relatives. That also is not recognized. So there was the need to recognize that all forms of violence in family relationships, protection of the right to live in the matrimonial home, and to address all forms of violence. So with those aims in mind, the DV Act was enacted. So it was enacted as a law to provide immediate relief, and then and so that the relief would be fast and not slow, and that these protection orders are provided immediately to women. Now what I want to do is today's discussion, I want to just raise some case law or some new themes, because I feel perhaps some of these new judgments will be useful to all of us. Often we don't get the time and chance to keep ourselves updated with new decisions. We do it only when we have a particular case on that particular issue. Then we may do it. But we may not be able to keep abreast with all the changing issues. So I would like to go on some more themes of the judgments have come. And then end with what are still some of the difficulties we are facing. And then I think it would be great if we have some interaction or some questions or some comments and inputs. Yeah? So I'm looking at, I've tried to address new judgments on many themes which in the last 4-5 years the Supreme Court and different high courts have come up with, and on a variety of issues, on limitation, on shared household, on jurisdiction, many areas of the law. So one of the issues that came up is who can be the respondent. Now the DV Act makes it's very clear that the aggrieved person has to be women, because it is for women, and the respondent is an adult male for the purpose of certain reliefs. Of course, there can be even a lady who is committing domestic violence. In many cases, if it's a woman who is married and is taking mother-in-law may also be there. But the Domestic Violence Act says very clearly that for the reliefs of, say, residence orders